The President, please be seated. The court is now back in session. Mr. Co-Prosecutor, you have the floor now, and please be brief, Mr. Co-Prosecutor.
Thank you, Mr. President. I will try to respond to the defense positions as quickly as I can. When I left off, I had just responded to the concept that was advanced by the defense that they had been prejudiced either by the original severance order as it causing confusion as to how to proceed in the trial or by the Supreme Court Chamber's decision. And I wanted to make clear that we are in no way in a position that we cannot proceed at this time because of this fundamental purpose of the original trial of building a foundation that would support all crimes. Let me turn now to the arguments that were advanced by Mr. Kopi, specifically on the representativeness issue, which, as I said, is the main area of disagreement of the parties as to what exactly should be included in the trial. Mr. Kopi argues that our proposal is not representative because it does not accurately or fairly represent the revolution that his client was attempting to implement in this country. And I believe he's missed the actual test. We've heard from the Nunchea defense throughout this trial complain that this is a political trial. Now it seems that the Nunchea defense wants to turn this into a political trial where what is judged is the politics of the regime rather than the criminal issues in the indictment. So when this court considers representativeness, it is not that this trial needs to be a form on the Communist Party of Kampuchea. When we talk about representativeness, it is to select crimes, the crimes from the indictment that are most appropriate to try against these accused, that fairly represent the criminal charges of this indictment. And the reason S-21 is advanced is very simple. It was the most important prison. It is a prison from which prisoners from every region of the country, every organization, the military, the provinces, the ministries, all people were subject to this prison, unlike other security centers. And it is a prison that was literally within a mile of where these accused were located, a prison that reported directly to them. It is at the core of the criminal charges against these accused, and that is a fundamental consideration in deciding the scope of the trial. They also argue that S-21 is not enough, that there needs to be more. There needs to be more crimes added in order for this to be representative. We disagree with that position. We believe S-21 is sufficiently representative. And let me say here in response to arguments that have been made by all the teams that what the Supreme Court Chamber decision requires is that the Chamber make an effort for the trial to be reasonably representative. It certainly will not be possible, we believe, for it to be completely or perfectly representative. Given the circumstances, the effort that must be made is to find a trial that is reasonably representative. And unfortunately, that means that we cannot, in our position, we cannot include everything that is in the current indictment. That is obviously something that is painful to all of us, but it is the reality of the situation that we all face. However, if the Chamber disagrees with us and agrees with Defense Counsel that S21 itself is not enough to satisfy the representation issue, there are other options that the trial chamber could pursue other than trying the entire case too. We do not think it is necessary to add more than S21, but you need not add all charges of the indictment. Let me give you just one example. Mr. Carnivus has pointed out to you that in one of our filings we proposed some additional sites. One site alone that would the trial chamber could look at it if it believed it needed to add more than S21 is the Tramcock cooperatives. And I raise that particular crime site for a couple of reasons. First, Mr. Copy says that we need to have a crime site to see where the policies of the revolution were implemented. The court may remember that Tramcock District was recognized by the party leadership as one of the 3 model districts of democratic Kampuchea. Therefore, this is a crime site that, even in the Nunchea Defense's position, has been endorsed by the party as one that operated according to the principles of the Communist Party of Kampuchea. The allegations in this crime site are fairly broad. The allegations in the closing order, paragraphs 304 to 306, concern the influx and treatment of evacuees and new people in that district. Paragraphs 307 to 311 deal with forced labor, cooperatives, and lack of freedoms. Paragraphs 312 to 313 address lack of food, starvation, and health problems. Paragraph 314 addresses forced group marriages in that district. Paragraphs 315 to 318 relate to the treatment of enemies and the Krang Tachan Security Center. Paragraphs 319 to 320 concern treatment of Lon Nol officials, Cham, Vietnamese, and Khmer Krom, and paragraph 320 deals with Buddhism and disrobing of monks in that district. Now, in making our proposal to you, we had to make choices. We evaluated what was most important and what could be done in the most efficient time. But this is an option that is available to the court if it believes it needs to add more than S21. And if that were the case, we would certainly respond to you with a plan for the expeditious trial of that crime site also. The other issue that I wish to respond to, and with respect to the Nunchea team, concerns their responses to the trial chamber's question as to additional witnesses or documents that would be needed. In fact, I will make this comment for the Khieu Samphan team as well. Both of them said they could not respond precisely at this time and needed more time to address this issue. I would simply remind the chamber that this exact question was asked of all the parties, including the Khieu Samphan and Nunchea teams, back in August of last year. They were asked what additional witnesses they would need, what additional evidence would be needed if S21 was added. there was a lengthy period of communications with the senior legal officer, the result of which is a document E-236, a document that respects or collectively indicates the parties' responses to that question. And in paragraph 7, the Q Sampan team advised that it had no further individuals to propose regarding these additional crime sites, including S21. The Noon Chea team provided a list of 31 people, which I referred to the other day. So I am somewhat surprised by the responses from counsel that they need more time to answer this question, as it was asked and responded to by them over at least 6 months ago. In any event, the court should be directed to this document because this was the result of at least a month's effort and consultation with the parties, specifically on this question of whether any additional witnesses would be needed on S21. Turning quickly to the positions of the Ing Sari team, as I mentioned, Mr. Carnavas spent much of his argument not addressing the questions that the trial chamber had raised, but rather making an argument attacking the validity of the Supreme Court chamber decision and seeking to put blame on who is responsible for this issue. I would simply say first that this is not productive. This is not helpful to this court. This court is looking for guidance in response to these questions as to how to go forward. I am not going to spend any time responding to the assertions that we are to blame for this problem or who is to blame. The suggestion that this court can simply disregard the Supreme Court chamber's decision because they are acting you to act ultra vires does not merit any response. I would simply note that Mr. Carnavas makes much of the issue of the representatives requirement not being in our statute, in our rules. What is in our rules, I would just remind you, is a requirement that severance be in the interests of justice. And the Supreme Court chamber has now made an interpretation of what that means. And that interpretation relies on analogous precedent and rules from the ICTY. We all recognize that there are some differences between the ICTY rule and our rule. This is an interpretive guide for the court in determining how to apply the interests of justice requirement in our rule. The other issue that Mr. Carnavas has raised is that he seeks certainty. He asks this chamber to be definitive about what will happen with the claims, any claims that are severed. The suggestion that in any way we have proposed dismissing those claims is incorrect. As I stated the other day, that is not a part of the authority that is provided under Rule 89. Just so we are clear, what we are proposing is that the court sever some of these crimes and charges, not dismiss. And unless this court decides to continue with the notion of a series of trials, the Supreme Court chamber decision does not require you to set a plan. If you go for what we have called option B, which is to proceed on the assumption that there will be only one smaller trial and to make that representative, you're not required to have a plan for other trials. because the assumption is that that prospect is intangibly remote. That does not mean that we should not consider what do we do with the severed charges. And our position and suggestion on that is fairly straightforward. If the court does pursue option B, which is one trial rather than a series of trials, our position is that the severed charges should be stayed and that the court should schedule a hearing following the issuance of its judgment in the trial. At that time, this court can consider all the relevant factors and make a decision on that time on how to proceed with respect to the severed charges. That would include, of course, an evaluation of where we are with the health or fitness of the accused, the position of the court, and a multitude of factors that the court could look at. And I raise this issue also because the Q Sampan team has said, what about me? I am more healthy. And we cannot completely discount the possibility that when judgment is reached in the first trial, 2 of the accused may not be fit to proceed, 1 may be. We simply do not know. But that would seem to me that an appropriate time to table the issue of how to proceed on severed charges would be immediately following a judgment issued by this court in the first trial. And turning to the positions of the Q Sampan defense, I don't think that this court will obtain much benefit in its decision from their positions. The most telling statement that they made to me was, quote, "Whatever you decide, we will be prejudiced. Whether you pursue the entire case too or adopt many trials, we are prejudiced." So, to me, from our perspective, the Q Sampan team has declined, respectively declined, not to give this court much guidance on the issues that it has asked regarding the scope of this trial. And I must also note that they have, in their submissions, made many complaints about their client's right to a speedy trial. And certainly it is our view that, given all the obstacles, we have proceeded as quickly as we can here. I would note that Q Sampan himself was in the hospital this month. But what I wanted to observe for this court is, at the same time that the Q Sampan defense is asking for a speedy trial, suggesting that they should be severed and released, at the same time that they are saying this trial is not proceeding quickly enough, they are asking for more time to prepare for S-21. They asked to defer the hearing of their character witnesses just a few days ago. They cannot have it both ways. If they want to proceed expeditiously, then we will proceed expeditiously. They themselves are regularly making requests to delay the proceedings. That is inconsistent with the position they are now taking, that they have been prejudiced and that the right to speedy trial has been violated. There are many other issues that were raised, many that have nothing to do with the matters you need to decide. I will not respond at this time to the merits of the Q Sampan proposal that he be released, placed on house arrest, and the case against him severed. We will respond to that if the Q Sampan team makes a motion. It seems to me that this is a serious matter that needs to be made in a motion to the court and responded to by the parties, and is unrelated to the matter presently before you, which is the scope of the future trial. Well, thank you for the opportunity to respond, and that is our observations on the defense positions today.
The President. Thank you, Mr. Co-Prosecutor. Now I hand over to the lead co-lawyer for the civil parties to respond or reply to the responses by the three defense team. You may proceed. Counsel Pech-ong. Good afternoon, Mr. President, Your Honors, fellow members of the defense teams and colleagues. I would like to reply to a few issues raised by the defense team. The first point I would like to respond to the collective stance of the defense teams that they do not envisage that there should be any severance of the whole case. They want the case to be tried as one, and I would like to respond to the observation made by the defense team as he quoted his client saying that if the case was to be severed, then only portion of the history would be brought up to be heard in the court. The entire history of Cambodia would not be reflected through the proceedings of this court. And he further stated that this court is to find the truth, is not only meant to bring up only a few or portion of the history. And it is worth mentioning that this court is not is not mandated to find the entire history of Cambodia. And of course, the court that we are now attending cannot address the entire history of Cambodia. And of course, during the hearing, the accused would be given the opportunity to tell the truth, which is part of the history that is beneficial to the younger generation of Cambodia. So the assertion by the defense teams that any severance of the case would not reflect the reality of the history of the democratic Kampuchea or the period was not appropriate. And in addition, the defense team for Mr. Nguyen Chia also added that even though there was a severance of the case, the defense team had actually mentioned a number of facts as well. He discussed the roles of the accused, and we also dealt with the population movement, phase 1 and 2. As a matter of fact, the chamber heard those facts. And we believe that through additional testimony as well as evidentiary documents, we will be able to tell the truth of the period. And in response to the observation by the defense team for Mr. Kyu Sampon, which refers the severance of the case to the potential delays of the entire proceeding. I am of the opinion that any possible delay would not be the result of Mr. Kyu Sampon's intervention, but it was because of basically the health status of the co-accused, and I believe that the chamber has reasonable basis to decide on the severance based on Rule 89 bis of the internal rule. But the chamber will, of course, have the discretion to decide as to what scope of the proceeding to be heard in the first phase. And as for another point which I got through the translation, and I don't know whether or not I got it right from Counsel Carnavas, he asked whether or not the civil party lawyers did consult with their clients concerning the representability of the case being heard. If I understood Mr. Carnavas correctly, I stand to be corrected, but I would like to emphasize the stance of the defense of the civil party lawyers, that we have our internal working procedures among the civil party lawyers, and we worked very closely with the civil parties and with our fellow colleagues, and I don't think that that needs to be raised into debate or discuss in this court. And I believe that we have our own strategy to defend the interest or represent the interest of our clients, and I will not question whether or not the defense lawyers have consulted or discussed with his client, because it is entirely internal matters of each team. And in response to the observation made by Mr. Michael Victor Kope, who asserted that S21 should not be the fact incorporated in the trial, and it does not necessarily reflect the representation of the entire case. If we look at the S21, the prisoners detained and executed at S21 came from all walks of life in the period. They were ordinary people as well as senior officials in the government at that time. For example, one of our civil parties, Mr. Chum Mei, was a worker at that time, and he was also in prison at S21. And if we look at the geographical representation of the prisoners in S21, they were from different corners of the countries. So I think that the inclusion of S21 is clearly a representation. And we can also examine other evidentiary documents, particularly the living witnesses and civil parties who may bring along with the story, as well as other documents to testify before this court. And Mr. Carnavas also mentioned that certain fact has already been adjudicated, and it should not be brought up again. Please bear in mind that in case 001, Dutch was the only accused, but in case 002, there are co-accused. And we cannot assume that the facts that has already been adjudicated could not be brought for discussion in the next trial. Judge Claudia Fens mentioned that the trial of this nature may last up to 10 years or so, taking into consideration the advancing age of the accused. If it continues up to 10 years or so, we may run the risk of not having any verdict. So there might be a question, why we should establish this court in the first place. The civil parties who are participating in this proceeding is to claim for the justice. So they want to see justice done for them. So we want actually to see the verdict to be rendered by the chamber. So even if there is anything happen, for example, the death of the accused, at least one verdict was rendered by the chamber so that the victims will be able to receive some sort of justice. They know that what was right and what was wrong during the period. And in that sense, they would heal the wounds of their past, and at least partially the victims could attain some justice. The defense team seems to have articulated that there should not be any severance of the case at all. And according to the decision of the Supreme Court chamber directing the trial chamber to revisit the mode of severance of trial of case 002. So this is the mission of the trial chamber, and it is the discretion of the chamber to decide whether or not to sever the case or not. And I believe that the trial will have to go forward no matter how. And I simply support the points raised by the co-prosecutors. And I believe that we have to decide on the appropriate representability of this case so that it is feasible, viable, and substantial for the parties as well as the victims. On a separate point, concerning the reparation, which was also touched upon by the defense teams as well, I have my esteemed colleague, Simon Ford, who will enlighten the court on this point. But I would only like to pick up only one point from the defense team of Mr. Nguyen Chia, who said that we could not eat a cake and have it too. And I would like to make my point on this as well, on the viewpoint of the civil parties. We civil party have many people, and we have one slice of cake. We will share with each other, no matter how small it is, but we will have to share. But I don't want to elaborate further on this point because I will leave it to my esteemed colleague, Madame Simon Ford, who will take the floor from me. The President, thank you. Yes, you may proceed, but please be reminded that you should be brief on each point, and please go straight and to the point.
Thank you, Mr. President. I don't intend to take up too much of your time. I want to make a few points. The least we can say at the start is that the extraordinary decision of the Supreme Court seems to be eliciting equally extreme and extraordinary positions within this courtroom. And the first extraordinary thing that I heard today was that 2.5 defense teams explaining to us by some kind of logic that we had to think in terms of the entire trial today, while in 2011, as the prosecution reminded us, some of them said that severance was the best chamber decision. And now we are being told that we have to look at the entire trial and that is interesting. I would add that the Kyo Sampan defense team is in a rather difficult position as well, because apparently neither severance nor the complete trial is a good solution. I can see that from the point of view of an accused. It is preferable not to be tried, but I think, frankly, it is necessary to opt for one of the two solutions. When, in October 2011, the Chamber decided to sever, we all agreed on the fact that severance was something that was possible, and the defense said nothing other than the fact that they fully supported severance. One has to ask oneself what the reasons may be for them taking a position today that is diametrically opposed, and I believe that these reasons should not be found within a legal context, because it's nothing to do with law, in my opinion. I believe that the position has been evinced by Mr. Kyo Sampan. It's very simple. There are two accused who are extremely weary, who have difficulty in attending the hearings, and whose fitness is regularly called into question by their lawyers, and who, of course, say to themselves that thinking in terms of a new trial in its entirety is a way of not being tried. And then on the other side you have Mr. Kyo Sampan, who is in rather good health and who is understanding that he may be tried on his own, whatever severance or lack thereof there is in the trial, and obviously that is somewhat problematic for him. If two defense teams today are supporting the lack of any severance, this is a purely strategic consideration in the hope that they will never be judged. I would add a few additional words on the reasons that have been adduced. I heard, for example, that Mr. Nunchia believed that genocide was essential to the process, to the trial. That, frankly, is surprising. I agree, as I said yesterday, in the sense that the legal attributes of crime cannot themselves be subject to severance. Now, I have to say that my position is legally based, and there should certainly not be any severance on the nature of the crimes, and genocide should be included among those items that are referred to in the trial, including, for example, religious persecution as well, etc. I also heard an argument put forward according to which we had to respect the accused's entitlement to an expeditious trial. I'm not sure if being expeditious is to have the entire trial or to have severance. I didn't quite understand the link between cause and effect in that particular argument, but I do have to stress that a timely trial is not the privilege of the accused, it's also a right that belongs to the civil parties, and that is precisely what we have been advocating from the start. I also heard the defense saying that if you decide to accept S21 in the trial, then the accused would suffer from the uncertainty that continued to reign over the scope of the trial. Upon which I would respond that the S21 request is 16 months old. There have been repeated discussions on the subject, and ever since the start we have all imagined that S21 could be included in the trial, in addition to the fact that the Chamber itself said from the very outset that it reserved itself the possibility of including it. This, therefore, does not cause prejudice to anybody, and everybody has prepared their files taking account of that. The second extraordinary thing that I heard today relates to the civil parties. I'm only too delighted to see the outstanding interest that all of a sudden two defence teams have in the civil parties. I fully support my colleague Pick Ong's comment. I don't think it's up to any council here to ask us to explain how we consult the civil parties. I heard the defence councils talking about abandoning civil parties, sacrificing civil parties, and so on and so forth. Yesterday, basing my argument on the relevant law in the ECCC, I said that all the civil parties collectively participate without a single one being excluded in all trials before this chamber, and I didn't make that up, nor is it ridiculous. It is the law that applies in the ECCC. I didn't hear a single legal argument put forward today to contradict what I said yesterday, and I would ask the chamber to take that argument into account. It applies to the participation of the civil parties, and it is also intimately connected with reparation and the allocation thereof. One final point is that there appears to be a certain amount of misunderstanding about trials, single trials, mini trials, different trials, series of trials, big trials, and so on. I totally disapprove of the term mini trial, which has been echoed very widely in the media and which I consider extremely regrettable. But I would like to say that severance does not make it possible, does not allow the chamber to bring to a close the facts upon which the trial is founded. In civil law, the chamber is seized with all of the facts, and it cannot decide that there will be one single trial. Legally, it is an impossibility. On one side, you can assess the risks of, in practical terms, only one trial happening, but that is completely different to what the chamber can do, or the prosecution. Neither the chamber nor the prosecution can say there will be only one trial. The only thing the chamber can do is bring about a severance, and in deciding to do so, the chamber does not remove any charges from the file, nor the legal attributes of the crimes. It judges individuals first and foremost, and it is legally obliged to continue to try the remainder of the entire file unless any external event prevents it from doing so. So we cannot talk about a single trial. We have to say a first trial followed by others. Because we are aware of the risks, the chamber can think of severance in terms of a first representative trial. And if the risks do eventuate subsequently. But before that happens, the chamber has to give a timetable, calendar, whatever you want to call it. You can be scornful of it or not, but the chamber has to provide a timetable. It is bound by the closing order, and it cannot take an initiative to do anything else in the current juncture. So what we want to see, yes, is a severance with a first representative trial. We would very much hope not to hear the term mini-trial being repeated in the future. We would ask the Chamber to plan for future trials, and we believe that all of the legal aspects should be maintained, because under severance it is not possible in civil law to pick and choose among different types of crimes. So there are not certain kinds of crimes that can be set on one side in this kind of process. Thank you, Mr. President.
The President. Now I hand over to the defense team to reply to the co-prosecutor or the civil party lawyers. We may start with the defense team for Mr. Nguyen Chia first, if you have any last reply to these issues. Counsel, please be reminded to be brief on your reply.
Thank you, Mr. President, Your Honours. I am mindful of the time, but maybe I need 10 minutes to reply. If that is not good for you, maybe we can do it tomorrow. But I'll give it a start. I think there's an old Spanish proverb that says, "A wise man changes his mind, a fool never will." But the thing is, I don't think the Nguyen Chia defense team did really change its mind. The submissions about the decision of the original severance were indeed applauded by my predecessors. But that was done in, if I'm correct, October 2011, before the trial started. Now, when the trial was on its way, it was our client himself who said at one of the first trial days, 22nd of November 2011, that, and I quote from the transcript, "I am of the opinion that this court is unfair to me since the beginning, because only certain facts are to be adjudicated by this court. I must say only the body of the crocodile is to be discussed, not its head or the tails, which are the important parts of its daily activities." So it was my client who was criticizing the way he felt restrained already in the first days of the trial. And that has been his position ever since. He felt curtailed, and that was the thing that we were trying to say this morning. So I beg to differ that we are not the mother of flip-flops. As a matter of fact, I think the grandfathers of flip-flops are sitting opposite of me, because they were the ones who drafted the original introductory submissions, on basis of which the closing order was drafted. It was them who thought it wise in 2006, 2007, to put the whole DK regime on trial. All the crimes, including genocide, came from the original pen from these grandfathers of the flip-flop. And now, I'm saying that now they want to reduce this trial to the forced transfer NS-21. So who is changing his mind here? The other thing I would like to say in rejoinder of what my learned friends have said is the things that I have said earlier about genocide, and the fact that it is really deeply the wish of my client to be able to defend himself of these charges that he finds himself innocent of. Now, next week, as I understood, it's a recess week. I'm going back to my country, where I will listen to a judgment in a case in respect of the Rwanda genocide. Now, time and time again, in cases in respect of what happened in 1994 in Rwanda, genocide is always cited as the crime of all crimes, the most important thing, the most grave accusation that someone can make. Now, I hear nothing from the civil parties in respect of this serious accusation. And it is not accurate. I mean, just read the closing order to say that S21 is representative of the closing order. The civil parties might argue that the victims there, the alleged victims, come from all walks of life, but obviously that is not the case. For instance, I just give one example because of time. No Chams, to my knowledge, have ever been killed in S21. Mr. President, I will finish because we don't have time. The one thing that I do have a problem with is the fact that we are now being accused by the prosecutors as causing chaos and delay as much as possible. That is not the case. We are just trying to ask your chamber to have our client tried in such a way that he can say all the things that he really wants to say. And about the delay that might be caused by having one big trial, I could say the following. When we break at 4 o'clock, there's only 3 people who do not go home. There's only 3 people who go back to prison. They are the ones awaiting this trial. They are the ones right now most affected by a prolongment of the procedure. Thank you.
The President, thank you. Now the defense team for Mr. Ingsari, you have the floor to reply to the responses by the co-prosecutors and the lead co-lawyers for the civil parties.
Thank you, Mr. President. Good afternoon, Your Honors, and good afternoon to everyone in and around the courtroom. I'll try to be brief. I'll cover the major points. First, misrepresentation by the prosecution that we all agree on one trial. We agree that we should have the entire trial, one trial on case 002. We do not agree that you should have a trial that is merely representative of a sampling of the closing order. We were clear on that. And from what I hear from the prosecution, although later they want to cover themselves, what they're saying is there's only going to be one trial. And then later on, when they talk about the interest of justice and how it was defined by the Supremes in this case, is it in the interest of justice for you to dismiss the rest? Is it in the interest of justice if you're going to take 1 year or so in rendering your decision, your judgment, to then say, okay, let's see who's sitting around, and we've heard that perhaps it may only be Kyo Sampon. Now let's put him through the meat grinder of a trial process once again. Is it in the interest of justice, and is it consistent with the principle of having a fair and expeditious trial? Is that an expeditious trial? The answer is no. The prosecution accuses us of changing our position. I won't go into flip-flopping because it may not translate very well, but essentially they're saying that we changed our position. That is a mischaracterization, because if you look at what we filed in E124/3, which was Ingsari's conditional support to the co-prosecutor's notice of request for reconsideration, And then our subsequent filing, which is E124/6, which is our response to their request, we were very consistent. We agreed to the approach taken by the trial chamber. We disagreed. And in fact, if you read our submissions, Your Honors, you don't even have to go beyond the first paragraph, because in the opening paragraph, I set out the reasons why we are compelled to respond and why we submit the prosecution's motion for reconsideration in severing case 002 in the manner in which they proposed was wrong-headed. And we maintain that position. We maintain that their interpretation of Rule 97-ter is erroneous. Now, we've heard from the Supreme Court. I disagree vastly with their interpretation of using Rule 73 bis D, which is doing away with counts, as a means of interpreting Rule 89 in the ECCC, which deals with severance. But be that as it may, we submit that you must try the entire case. And now that we've heard from the Supremes, and now that we've seen the options that are available, I won't quote a Spanish saying, but in the U.S. we say, when circumstances change, so should one's opinion. Or at least they should consider. And so we have considered it, and we are entitled to change our opinions when circumstances change. I thought I had it right, but I am told differently from the Supremes. They're telling us that we are in this adversarial setting a la ICTY, hence the position that we're taking. The prosecution says we are causing chaos and delay. Chaos and delay. Well, let me remind the prosecutor. They had Stephen Heder working for them in drafting the introductory submission. And then they embedded him, or he embedded himself, into the OCIJ and essentially confirmed what he had already written to investigate what he was already putting into the introductory submission. And not only that, it was the OCIJ that asked for supplementary submissions, or they asked for supplementary submissions, and of course were granted. So who has caused chaos and delay? We are not setting anything at your footstep. We were presented with this situation. The trial chamber moved. We supported the trial chamber's position. And then I am shocked. I am literally shocked to hear the prosecution this afternoon stand up and wax eloquently on the decision, your decision, on the rejecting their motion for reconsideration. And I'm wondering, why on earth did they appeal? It seems that all of the answers were in there, which also shows you that you did, in fact, issue a reasoned decision, because we just heard it. They embraced it. They use it. And so we have not created a nightmare scenario. We're responding. And where there's action, there's reaction. Now, more or less, I've covered what I needed to cover, Your Honors. The only point I wish to make is as follows. You simply cannot park the remainder of the closing order as is being suggested. And they say, quite interestingly, well, you have not been ordered. Well, you don't need to be ordered by the Supreme Court chamber. It is within your duty, especially since you've been lectured by the Supreme Court with option number 1, and before that in the entire decision why you haven't provided a plan. But we would submit that it is implicit. It is an implicit obligation of the trial chamber, based on the Supreme Court's order, ordering you to come up with a plan that if indeed there are going to be more trials after the mini trial that is being suggested by the prosecution, then you still are compelled to have a plan. And as day follows night, if there is no plan, but merely here it is, we'll see what happens later on, I can assure your honors, that the inquiry team will certainly be filing an appeal. Now, I don't know what the Supreme Court chamber will do, and it will be interesting to see whether indeed they will change their position to conveniently fit whatever decision they have in mind. But we submit that if you decide not to try the entire case of 002 as reflected in the closing order, that you have to come up with a plan. And you can't say, we'll figure it out 1 year after the close of the evidence when we reach the judgment. Y'all, just don't worry, be happy where you are. You have to do that. It's implicit. And with that, Your Honors, I want to thank you very, very much for allowing us to make these submissions. And we certainly hope we have been helpful. Thank you.
The President, thank you. Counsel for the Mr. Kyu Sampon, you may proceed.
Merci, Monsieur le Président.
Thank you very much, Mr. President. I, for one, wish to clarify the following, and I'm not sure if this stems from lack of understanding of our position or merely bad faith. But our stance is one in which we insist that the guidance, criteria, and directives issued by the Supreme Court chamber in the scenario that you would elect the first option would be equally valid in the case that you would opt for the second scenario. What this means is that this chamber cannot today simply decide that it can refrain from clearly defining the terms by which Mr. Kyo Sampon will be tried and on the specific facts and allegations that he will be tried based on the fact that he's in bad health and that he is going to die, which is not the case. And this is where I criticize the decision of the Supreme Court chamber and where my friends on the other side of the chamber are trying to draw an advantage. It speaks to paragraph 50 and 51 of the Supreme Court chamber decision, according to which it is stated either we deal with successive and multiple trials, in which case many questions and matters would have to be answered, and that would require a timetable, as was directed by the Supreme Court chamber. In fact, it orders much more than that. It talks about developing a very specific and exhaustive plan in order to cover the totality of the charges. And in paragraph 51, it goes so far as to state that the chamber must decide as to whether or not there should be a second trial panel, or if there is any appearance of bias of judges from the first trial adjudicating the second trial. As far as the first option is concerned, the Supreme Court chamber has ordered a certain number of elements, and as far as the defense team for Mr. Kyo Sampon is concerned, those directives are entirely valid in any hypothesis, in any scenario, whether you go with option 1 or whether you go with the option of holding a trial that is more representative of the crimes, because Mr. Kyo Sampong will live to see the day of those trials. And you, Your Honors, have said so yourselves, as well as the co-prosecutors, and it was echoed by the civil parties. He will see through the remainder of the closing order, and this is precisely why I talked about false choices, fictitious alternatives, because in reality, this Supreme Court chamber decision states that all of the problems must be raised, and this is exactly why we have stated and argued and not alleged, as the civil parties have, that neither the severance order nor the trying the totality of crimes would be the ideal solution. We are not trying to find this to devise the ideal solution. We are here to defend Mr. Kyo Sampong. We are here to call to your attention the prejudice that we are subjected to, and regardless of the choice that you would embrace, that is, to go with the first option, to try the entire case file, or the second option, which is to try successive cases. Either way, we are subjected to a prejudice, since this trial has been underway for the past year and a half, and for the past year and a half we are completely ignorant of the facts on which we are being judged, and we are under extreme pressure and duress to expedite these proceedings. The trial chamber is trying to impose restrictions on page numbers and finding other ways to impose restrictions. All of these are examples of the prejudice that we are being subjected to, and the Supreme Court chamber decision was very clear. There is harm, there is prejudice. Therefore, with that clarification, Your Honors, I hope that the opposition understands the position of the Kyo Sampong defense. And to conclude, when our friends across the way state that we can await the results of the first representative trial to state to Mr. Kyo Sampong how he will be judged subsequently, well, we outright reject and refute that possibility. We assert that this would be a continued infringement of the rights of Mr. Kyo Sampong, and that it would only sustain the prejudice that we are suffering. We have just been criticized for not being logical. In our comments relevant to S21, I believe, given the allocation of time, I was rather clear, and I laid out my arguments. This would be something only considered by the chamber during its deliberations. And I believe that the criticism launched by my opponents is not well-founded. And in terms of the postponement of the hearing of character witnesses, once again, you take us for fools. We are the defense. We are not here to make sure that there's going to be a speedy conviction and to allow Mr. Kyo Sampong to be lynched and pilloried. We are here to defend him. And I think that's entirely clear. Your Honors, those were the clarifications I sought to put before you. Thank you very much.
The President. Thank you. Thank you for the various views from parties concerning the question raised by the Chamber. The time is now appropriate for the day adjournment. The Chamber will adjourn now and will resume tomorrow starting from 9 o'clock in the morning.
Okay.
The chambers advise the party to respond to the various questions raised by the chamber as indicated in memorandum dated the 19th of February 2013, document E264. So the chamber advises the party that they are well prepared in response to the question, so that the proceedings tomorrow will be smooth and you respond to the question appropriately. The chamber wishes to advise the support staff as well as members of the public of the upcoming hearing. Security guards are now instructed to bring the co-accused back to the detention facility and have them back to the courtroom before 9 in the morning. Mr. Ieng Sari is to remain in the holding cell downstairs, where audio-visual equipment is there to connect him to the proceeding upstairs. The court is now adjourned.